Hi, Allie. How are you?
I'm good. How are you, Don?
Good, good. I just got back from the University Club. I was there on a meeting, and driving from the University Club to this office is it's less than a mile, without a doubt. Okay. Let me tell you something. I felt like I was on the 405 freeway. You know, it seems to me that since COVID is kind of gone, the freeways are less than what they used to be, at least coming from here to the downtown. I could get to the courthouse in about 20 minutes now, in Central Courthouse. But if I'm driving home when I live, usually about 5 minutes away, I mean, it's unbelievable how many cars are out there on these surface streets.
I had the exact same thing happen yesterday.
Yeah.
I was just driving home. I had to pick my son up over here in Pasadena and just going to Eagle Rock. I was like, what? Just on Eagle Rock Boulevard there was traffic. I'm like, when is there a backup?
And you live close to to our office, just like I do. So I'm trying to figure out what is it. I mean, because I don't know if the population of the city has grown that much. I mean, there's been a lot of development with regard to these new like condominium complexes and stuff like that. But I've got a theory, and maybe somebody out there could help me with this, tell me that I'm crazy. But it seems that people aren't necessarily going back to work because there's a lot of remote workers still. But I think people just need to get out. And they're just out and about more than before. I don't want to solve all the world's problems today, but I thought that I'd bring that up, and it's good to know that you're experiencing the same thing. I'm not absolutely crazy, and stuff. Sometimes I get, you get these thoughts and you think, am I just being crotchety? I'm older, I don't like to drive as much,
That might be it too.
I wake up, that could be. I wake up in the morning, I got pains that I didn't have when I was younger, and now I'm dealing with traffic that I hate.
We also had this crazy weather here yesterday where the snow is so low on the mountains. I mean,
well, that's a nice thing.
Yeah, it was snowing in La Cañada yesterday.
Yeah. Now, you grew up in California, so you like snow because it's pretty.
Yes.
Okay. I grew up in Chicago. I hate snow, but I do like to look at it from my window and say, "Isn't that pretty?"
In fairness, it's beautiful up on the mountains.
Yeah, as long as I'm not walking or driving through it.
Yeah.
So, let's talk today about a case that's a crossover issue. And before the podcast today, we were talking about the fact that there's a lot of appellate court decisions that are being published that are dealing with crossover issues. We just had an end of the year review, and I think there was at least maybe 3 or 4 that we talked about. We're going to cover one of them today. And when we talk about crossover issues, what we mean is that Allie lives in the world of probate. That's where they're dealing with wills and trusts. I deal with family law issues, and typically, just like any area of law, they're universes of themselves, right? You don't deal with divorces. I don't deal with death and divorce, death and, people fighting over the estates and stuff like that. But because of the fact that our practices deal with families, there's an enormous amount of crossover issues. And this is going to be an example of why I think every person that practices family law should have a close relationship with somebody like you. And stuff. And, we're lucky that we have Allie in our office because these things happen all the time. So
if I can interrupt,
sure.
Sorry. We also have one right now, right, where the spouses are alive, but one is conserved.
Yeah.
Right? So one doesn't have capacity, is under a conservatorship. It's really important, too. We've had that numerous times over the years. So.
That's right. And not only that one, but I'm dealing with a case where the opposing party is being conserved, and if it wasn't for my working with you, that I wouldn't have any clue as to how that works and stuff. So,
right.
Yeah. Okay, so this is Welch v. Welch, and why don't you set up the facts for us so we can kind of put this in context.
So, Mr. and Mrs. Welch, Freeman and Patricia, were married for a long time, right? This is also common, these gray divorces.
Yeah.
36 years they were married. They filed a petition for dissolution. Freeman filed, Patricia responded, not that it's relevant. They ended up going to a mediation, and they came to an agreement, right? This language is a little outside of so forgive me if I'm not using
this is where I could, this is why, this is a crossover. That's why we work together. So we're in family law right now, okay? And so these people are going through a divorce after a 36-year marriage. They've got 2 adult children, and they attend mediation. People should know that 95% of all divorce cases settled without having to go to trial. And this is certainly an example of that. They go through mediation, and they prepare what's called a marital settlement agreement. Okay, and basically this is the global settlement agreement. We have signed it, meaning that it's going to be incorporated into a judgment of dissolution. We're going to avoid having to go to court. We won't have a trial. We're going to save a lot of money, and we're both satisfied with the results of our negotiations.
So husband files this with the court and asks the court to make a judgment of it, right? And wife opposes it because she has some changes that she wants to make. She says that it's not exactly what she agreed to.
Yeah, and so what happens with these marital settlement agreements, it's a very common problem that we have. Usually it happens when people are settling at the courthouse. So they have these handwritten stipulations, and people with their bad writing, particularly me, write up a draft of the agreement. And you can't include all the boilerplate or think about all the provisions that should be in a judgment. So even though you have an agreement on the big ticket items, by the time it comes around to preparing a judgment to reflect that, then there's bantering and arguing about what is in there. Hey, I didn't include that in there. I didn't mean that. Oh, and then sometimes people are being unreasonable where they're boilerplate template stuff that should be in there, but people are just fighting for the sake of fighting. So at this stage that you're talking about, husband and wife are now, they're no longer negotiating, the terms of the agreement. They're negotiating what should be put into the judgment, and one side is saying that's not reflective of our agreement. That side is the wife.
Right. So then he argues that the court should make the judgment regardless under
666.4. So he files a motion with the court and he says, hey, judge, you know what? She's being unreasonable here. You know what? We have an agreement. Read it. This is pursuant to the MSA. And I want this thing enforced. Sign it off as is. She wants to try to set it aside later on. She could try, but she's being unreasonable and she's holding up the proceedings. So, judge, would you sign it? Look at the MSA. Look at what I've typed up. Just sign it, please.
And that's important.
Yeah.
Right? That ends up being important that he says that to the court,
right,
based on what the decision ends up being,
right?
So the court ends up making the judgment.
Well, what happens is that the hearing for that issue is continued to June 25th, right? And so the judge is going to decide on the issue, and an unfortunate thing happens.
She died on June 16th.
Yeah, so the hearing never takes place.
Right. They appear in August, and they let the court know that Patricia has passed away, and so the court dismisses.
Well, but before that happens, though, in July, the court signed the judgment not knowing that she had died.
Right.
So the judge is going, well, that sounds like the husband had the better argument. I don't have any reason not to sign this thing, so I'm going to sign it, and he does so. But in October, what happens?
Oh, he moves to set aside the judgment because he's like, oh, no, I changed my mind.
Yeah, and this is where your world comes in.
I don't actually want to be divorced. I want to be the surviving spouse.
That's right. So what we had here is we have a husband that's strongly advocating for the entry of a judgment. Judge sign it. It's pursuant to the MSA. And then when the wife dies, he reflects on what he did, and he realizes, oops, I made a mistake because I will get more of the share of the property if I'm still married to her when she dies than when I'm not, right?
Right. And the court agrees with him, right? The court ends up saying that The
court sets it aside.
Right.
Yeah. Right.
Yeah. So then...
Now we're going into your world.
Flip. So then we go to probate court, and it appears that Brendan, right? Yes, Brendan.
It's the oldest son.
Who's the son of Patricia and Freeman, petitions the court to be appointed special administrator of his mother's estate, and he brings an 850 petition. And what that means in my world is everything that has left that estate, he wants to bring it back into her estate, right? Because it's gone to the dad. So he's trying to get it back into mom's estate. The court grants it, and his dad objects, and he files his own petition based on mom's pour-over will that appoints Freeman as the personal representative and executor of the estate. And this judge, there's stuff that happens, but basically this judge agrees. The judge stays it and waits to find out what happens in the family law court. And when the family law court says, yes, he is the surviving spouse, right? They died married, and now he's the surviving spouse. Our superior court judge says, okay, well, I'm going to grant Freeman's petition. He's a surviving spouse. He's going to be the executor of the estate, and everything's going to go by way of the pour-over will.
Wow. Well, so it looks like hubby is getting rewarded for his waffling.
Yes.
He wins in family court in getting the judgment signed. Then he wins in court in getting the judgment set aside. Then he wins in probate court, at least at stage 1, in getting the probate court to allow him to be, what is it called? The administrator?
The administrator, or the executor in this
The
case.
executor. So
Yep.
he's winning so far.
He is winning.
Okay.
Winning.
What happens next?
Well, then Brendan appeals that, and Brendan's argument is, we don't deny that he's the surviving spouse. They weren't divorced when she died. But he signed this marital settlement agreement, and that marital settlement agreement waived his rights as a surviving spouse, right? That was part of, and that's typical, right? That's what you put in the marital settlement agreement?
Well, I'm going to tell you, typically not.
Oh,
and that's
okay.
why this was a case worth looking at. I think this was
That
an
was a question for
eye-opener
me.
for a lot of people. Yeah. So they were referring to a probate code, right? It's a...
The 141 and...
Yeah.
Yeah.
Yeah, it was 141 et sec that talks about the settlement agreement. So what happens next?
So then what the court does, what the appeals court does, is they analyze it on, it's basically a contractual matter, right? And they look at, did the parties believe that this was a complete settlement agreement? And when they looked at it, they did say that Patricia had some issues with it, but she didn't have issues with the division, right? She had some other issues.
That issues with the general language that he was trying to sneak into the judgment as far as she was concerned. So it wasn't substantive stuff.
Right. So she believed it. And then he went to court and said over and over to the family law court, no, this is what we agreed to. This is a mirror image. This is a mirror image of what we agreed to.
Kind of hard for her to argue separately or differently when he goes into probate court, right? Oh, my gosh. I didn't pick up on that, actually. That's funny.
Yeah. I mean, I think that's what better evidence do you have than that, right?
Yeah.
That he believed that it was the full agreement and that he agreed to what was in there. So the judge, the appeals court, threw out the lower court's ruling and said, listen, he agreed to waive his rights as the surviving spouse, and, Brandon gets appointed at that point the daughter, I think, was going to be the executor of the estate, and we
Wow.
presume that it went by way of intestacy, which would be well, actually they don't get into that.
Well, I think that they were intestate here, right? Because that's one of the things I wanted to talk to you about. So one of the things that the court uses very much so is probate code section 141 et sec, and it deals with, unless the waiver or property settlement provides to the contrary, a waiver under this chapter of all rights in the property or estate or of a present or prospective spouse or a complete property settlement entered into after or in anticipation of separation or dissolution or annulment of marriage is a waiver by the spouse of the rights described in subdivision A of section 141. Now, that's a code that most family law attorneys, including myself, did not know about going into this decision, because what you have here is the fact that people are not divorced, right? Yet an agreement that they signed is going to be enforced in probate code, and it kind of sounds like a will to me, almost, like that. It's estate planning, and it wasn't meant to be that. But apparently this problem has arisen before, and so sometime, and I didn't do the legislative history, they created this to say that marital agreements can be enforced in probate code even when there's not a divorce, or especially when there's not a divorce, so long as two things happen. Number one is that it's a complete agreement between the parties, and two is there's been complete disclosure, right? So there's been this thing that we go through in divorce court where we disclose all assets and debts, and we make sure that our fiduciary duties are taken care of. And in this case, the court found that it had. And going along with what you had said, I believe that the court said, to the husband that, look, it doesn't have to be perfect. This was an agreement without a doubt. You guys agreed to this, and the fact that some things might have been left out in the disclosure, they weren't very material in light of the entire, the entire thing. And then he was complaining about the contract itself. It's vague. It's not. It's too open for a contest. That's why we were fighting. And the court's response was, contracts aren't perfect, right?
Yeah.
So.
The court in particular says, I was trying to find it, but I don't know where it is, where it particular says, like, there's lots of contracts people argue about afterwards, right? But it's still a contract, and it doesn't mean it's not an enforceable contract.
So one of the things that I thought was interesting in this case, it's a question, is let's assume that there was a will, on the part of the wife, and it was signed either before or after this marital settlement agreement went into place. And she didn't change that will, and stuff. I wonder what would control. I suspect that it depends on which one was signed later or what.
So, in this case, no. She could have done a will and disinherited him, and that's what she should have done.
That's why I think this was intestate, don't you think? This is probably why it was intestate.
I thought that it said that he had a pour-over will.
Well, what is a pour-over will?
So a pour-over will is what we prepare in conjunction with a trust. So when we establish a trust, we hope to put everything into the trust, but sometimes there's just things that either people forget about, or there might be something that hasn't come into your estate yet, but you vested in it. So let's say, your parent passes away, but during that administration, so it's not yours. You're entitled to that portion of their estate, but it hasn't come to you yet. The administrator hasn't written a check to you, and then you pass away. So the pour-over will would come into play to say, like, okay, this goes to Don. It was his, and so it's going to go over to his trust. So it pours over into the trust. But having said that, regardless, I guess it could be intestate because then the freeman would be the surviving spouse, and he would stand first in line to act on her behalf. But if she had executed a will, either so she wouldn't be intestate or to revoke her pour-over will, she could have named Brendan as her personal representative or executor, and just said that anything that she received, she wants to go to her children.
Okay. I'm looking at my notes here. This is why when I gave this presentation, I totally had to follow my sword to the audience and say, I don't know about any of this stuff. And one of the notes I have is the child, Brandon, filed a supplement to the petition nominating wife's sister to be the executor over wife's estate and successor trustee over wife's assets held in trust. So it does sound like there was a trust, maybe.
Yeah.
Okay, so that's why this is very fascinating to me, because if there was a conflict in her estate planning with the marital settlement agreement, it sounds like first, what was the last intent of her, or what?
Yeah, so that's true of the will.
Okay.
The trust is a little murkier because, as we know, we can establish a will without violating the atros, right?
Right.
So she could have done a will revoking her will. She can't revoke the trust without agreement of the spouse, the divorcing spouse. So there's not a bright line here. And a lot of times these things they're murky.
Yeah.
It's just kind of the nature of it.
And maybe it's also possible that her estate planning was done a while back, and it didn't reflect some of the property that was mentioned in the marital settlement agreement and stuff too. That's where your pour-over will would come into play.
Exactly.
Okay.
Yep.
I'm getting there somehow.
You got it.
So let's talk about some basic lessons. I know people, if you're hanging in there and listening to this whole conversation, you might be going, okay, what does this have to do with me, right? Well, to me, my lesson is that if you're going through a divorce, it is beneficial to get in and settle the case as early as possible by this decision and other decisions that we've covered recently in some of our presentations that we've given. You could see that there was no judgment of dissolution here, but it was that marital settlement agreement that had teeth in the probate code, or in the court there. I didn't know that, so that's pretty important that it's worded the right way, that you prepare it so that it accurately reflects what you want, and you comply with the code where you disclose everything, and it is a final agreement. It's probably a good idea to have an attorney, I would think, right?
Very good idea.
Yeah.
Now, let me ask you a question. So we've had 2 cases now that we've talked about these waivers, right? One waiver was in a premarital agreement.
Yeah.
Where the surviving, they were married when he died. I mean,
right.
These were married, but really married, right? They were together married, and she waived all her rights. And then now this one is also turning on a waiver in a marital settlement agreement. So do you include waivers in either of those typically? And would you moving forward if you don't?
I think that by accident, most family law attorneys include it because there's templates, and we have those in there. And if it makes sense to remove it, you would. Otherwise, you have it in there for protection. Going forward, I know what it means now, and stuff. So I'm going to include that. Or really, what it amounts to is sitting down with the client and saying, "What are your goals here?
Yeah.
What is it that you want?" Because you can't answer. You can't prepare these things assuming that every case is different, right? In this case. These parties could have felt a completely different way, and a premarital agreement would have been, if you just assume, you could have made a mistake. Yeah, a lot of lessons here.
Yeah, it's really important, and it's something important that people are waiving. Our clients should understand that.
Cool. Well, thank you very much.
You're welcome. Thank
This
you.
was great.